Hello, everybody. Sorry, I had catastrophic interference as I was trying to get ready. How is everyone doing? I'm trying to get to the top here, y'all, but my mouse is not accessible. Hello, Tammy. Hey, Foxtrot. Don't you love autocorrect? Hello, Lisette Panette. Good to see you. Hi, Nana Laura. Looks like Tammy beat me to it. I'm glad to see you're doing good, though. Hey there, Salty Buddha. Good to see you. Hello, Marquise Phillip. Hey, Brian Boggs. I'm glad you are. Hello, Shane. Glad you made it. Billy, go turn the heater down. It's hot in here. Hi, crazy old lady. Good to see you made it. Hi, CE. Glad to have you. Sorry, my hair is still wet from the shower. And doing whatever it wants, apparently. Hi, Rocky Lennon. Glad to see you, love. Tiana Miller. Good to have you. Hi, Stephanie. Is that me or Ava or Billy? Or all of the above. Let's be real. Oh my goodness. So glad you guys could all make it out. Oh, I really do have to adjust that heater. I had it off during the day and it was so nice out, and then it got rainy and cloudy and I didn't get the windows shut in time. And so now my house got really cold and I got all the windows closed. That took me a hot minute. And I turned my heat back on and I was like, well, I'm really, really cold, so I'm going to turn it up high and then I can adjust it. And then I forgot to adjust it. Yes, that's your Ava. That's your Ava. Yes, I know, the spoiled girl. Everybody's favorite girl. I found the cutest picture of her from about 2.5 years ago. Oh my goodness. I'll have to show you guys. Oh my goodness. Okay, we're going to do 2 tonight. Let me hear you. Let me hear you speak. 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 You have no excuses. Kendra's not home. Nope. Don't steal. Speak. 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 There you go. Good speak. Hold on. I'm going to show everybody your cute picture. Yes, you were so cute. Well, you still are. I know. I know. I think I've got... Oh, I see what I did. I've got to go into... There we go. See, I went on my messenger and I was finding pictures of my mom. And there was pictures, of course. Hello. Every bit the same as you were 2.5 years ago. Okay, there you go. Okay. Isn't that cute? I had a giant beef hip sliced bone, and she's just, oh, she's so cute. She wanted it so bad. Just like now, with these biscuits. Just, yeah, just like with these biscuits. Yeah, you want to tell everybody how cute you are, how nothing has changed. Nothing has changed. You're still the every bit is cute and every bit is demanding of treats. Yeah. Yeah, we all know. that is exactly. Yep. And pretty much she thinks Kendra's probably sleeping this time of night, but Kendra got dropped off at the bus at 4 a.m. and she's gone for a bit to Missouri. Now that she's older. I have a video of when she was a puppy. And like the person who had her their granddaughter or something just says Ava, and you just see her head doing this, I have no idea where that is though. Come get her. You gotta fight Jody Gardner for her, because Jody Gardner thinks she's making Ava and Black Lab AKC puppies. Yeah. Yes. You're such a sweet girl. You're such a sweet girl. Yeah, I know. The kisses are just for more treats, but I don't have any more. See, desk is empty. Desk is empty. Nothing more on the desk. Aww. Yeah, I know. I knew who you were talking about, though. Then how are you going to handle puppy support? Yeah, she's such a good girl. Except for she doesn't understand how posts work in relation to leashes. I don't know what she smelled. I don't know what she thought. All I know is I came out to get her, and I heard a little bit of whimpering and a little bit of rock movement, and there's not really rocks on her side. And so I went down to get her, and she is on the opposite side of the handicap ramp, she would have had to crawl under the handicap ramp. But then to top it off, she wrapped herself around the post. And she got pinned between the rain gutter and the handicap ramp and couldn't figure out how to get out. So I had to go down around and then grab her leash and like tug a little bit on the leash and then shake it to kind of like get her attention and then tug just a little bit more. And eventually doing that, she like fed her way around the post and back out through the hole and then pulled the leash through the slats of the handicap ramp and got stuck there. And usually I can just say, go that way. And she runs off the handicap ramp. It unhooks from the slats and then she runs back up the ramp. No, not this time. She had it stuck deep. Yeah. Not so funny when you had to be there. Because then I had to walk back down all the way down the ramp, step off the ramp, which mine's got an actual step. It's not a true wheelchair ramp because you could never like just roll a wheelchair up or down it. There's a step. And so yeah, I had to step down and walk about 2 feet off the ramp calling her, and she finally came barreling down and come running back up. Oh no. Oh, that would be awful. Oh, that would be terrible. You'd have to like rely on the kindness of a bystander for that one. I hope there was someone to help you. You just got Buddha too excited, that's all. She was the cutest puppy, though. She really was. And she was so much easier to hold back then. Like when I do like lay down in my recliner and she decides she wants to jump up on my lap, she's not as small as she once was. So I don't really lay in my recliner a whole lot. Oh no, naughty Buddha. Buddha keeping Daddy busy. Mizey would never do anything like that. Oh my goodness. Oh, I'm really glad you were able to get it unstuck. Yeah. Oh, I know. Snow makes everything worse. There's not a single thing that snow makes better. I'm convinced. Usually Buddha's the good one and Mizey's the mischievous one. Oh, and the Ava fan club sent some more of her best bully sticks. So she's in there munching on one of those, working that. No, you were just chewing on one. You were just chewing on it. You can't convince me you need a new one when you're in there chewing on the old one just fine. Go chew. I was showing chat. What a piggy. So the judge tonight, he's adorable. He's Reno Reno Mooney, or municipal judge, and he wears his freaking sweatsuit to court. He doesn't wear a robe. it's his sweatsuit, Nevada on it, and he's not a cranky old judge by any means. In fact, he when he speaks with authority, you don't believe it. But he is a good judge. Except for when it comes to the young ladies. The young ladies get deals that you know darn well the young men wouldn't get. Well, Judge Van at least wears polos. You know, maybe it's colder in Nevada this time of year. I don't know. But he is cute. He's adorable. And yeah, and he loves picking on his staff like similar to how Van does, but in a much more dad jokes kind of way. I mean, this man is all kinds of dad jokes. He's probably written a few of them in his days. But yeah, I really like him. Well, yeah, they are. Of course they are. They're not nearly as bad as spandex, though. That's a material that should have never been invented. Spandex is gross. Well, come on. Where did it go? How did it get unplugged? Dang cat butt. I blame the cat butt, y'all. We get to go on an adventure. Okay, search this PC. And now I can't do anything while it's searching. It's working on it. Salty, don't say things unless you have every intention of proving it. Yeah, deserts are hot during the day, but they are freezing cold. Like you can die from the cold in deserts. Yes, Shane. Absolutely. Absolutely. He's speaking of a type of undergarment, Tammy. That's the slang term for that type of undergarment that I can't say or I'll get instantly demonetized. I don't know what stylist sweats are, CE. Now I have to look. I don't know if y'all can hear her chomping away out there. Stylist sweats. Like, are they... Do you mean like hairstylist sweats or sweats you designed yourself? Or this is not very explanatory. Philip, that's hilarious. Tammy, it's perfectly fine for some people. There are just some people that don't look good in them. Some look great. How do I have one in here from January 14th? That was a long one, too. It's probably the last time I ran this docket. Oh, big name brand. Okay. That's why I had no idea what it was. I was thinking it was like sweats specifically made for hairstylists. Oh my gosh, guys. I am freaking out. The docket's not there at all. It's not anywhere. Like, I don't know if it got unplugged in the process of exporting, but I'm going to have to export it, which means I can't use this computer while I do it. I can load up PetCam and we can entertain ourselves with something else. How about we just entertain ourselves with something else? And I'll play this one tomorrow. I'll export it later. I am not. I exported it and it's not. I did search PC. It's not anywhere on this PC, and it's not on either of my drives. So something happened, and I didn't do it. No, I'm not. We will do something else. I will find something on YouTube. On the tubes of Ubes. Let's see. We did Manning recently. Let's see here. Give me a second here. I've never... Let's go to Lakewood, Washington Municipal Courts.
We're just waiting for the attorney to come on the Zoom screen, and then I think I see her now.
Good morning, Your Honor.
This is David Boger.
Good morning, Your Honor. This is Amendment Rule 9 on the record for Mr. Boger. Your Honor, we have, actually, first I will start with reading the cause number for you. Give me one moment.
This is why I cut spaces and pauses out. They do a lot of this, reading on the record.
I apologize. My O quartz is not working at the moment.
Oh, that's okay. I can read it out. It's 23L000988.
Okay, thank you, Your Honor. This is actually a matter that is a motion correction that needs to be done. I believe this is related to according to the docket, we needed to address the no contact order in this case. And so if the city has any further information on that.
I got to remind you every once in a while.
The information we have, I believe it reflects what Ms. Mon just said, which is that the parties did not address the $250 public defender fee. And I will just note that the city does not have a position. We do not object if the court waived that. And we would defer to the court about imposition of that fee.
Thank you. So my understanding, according to the my review of the docket, as well as what the parties just said, is that we have to recall the no contact order because this case was previously dismissed. And there's also the public defense fees. So Ms. Mon, do you have any information on Mr. Boger's financial circumstances to provide to the court at this time?
Your Honor, at this time, Mr. Boger would not be able to afford any fees, and I have no objection to waiving those, as Mr. Boger has been in custody for some time and currently is in a lot of financial hardship due to not working and losing his job.
Okay, so let's address the no contact order first. I will sign an order recalling the no contact order because this case has been dismissed previously, and that should have been done at the time of the dismissal. So we'll do that, and I will exercise my discretion and waive the remaining public defense fees that Mr. Boger has. So I'll just need some kind of work. I guess I'll need 2 orders uploaded. Oh, very good. Thank you.
And Your Honor, while we are uploading that, I would just like to note that the matter that Mr. Boger is currently serving his sentence on is the violation of a no contact order. The no contact order that will be recalled in this case would be for the prior assault 4 charge, which was dismissed. And I believe that that is matter ending in 375. And or excuse me, Your Honor, that was matter ending in 988.
988, correct. Okay, I've filled out an order if the parties want to review that. And if it looks good, go ahead and sign in, then I'll sign after.
Your Honor, I've reviewed, and I think this is reflective of our discussion. I have signed.
Thank you.
I am signing, Your Honor.
Thank you. Okay, I've signed the order at this time, and I believe that takes care of everything on this matter. Thank you, Mr. Boger.
So just a quick question, there still is a no contact order, correct?
Not on this cause number. You may have no contact orders on other cases. But on this case, it's been withdrawn.
Oh, okay, thank you, Your Honor. Appreciate that.
If you'd like to know if you have no contact orders on other matters, please talk to your attorney about that and they'll be able to advise you.
Okay, thank you, Your Honor.
Mr.
Thank you.
Boger, I'll have someone reach out to you.
All right, thank you.
Yep.
Have a good day.
You too. Can you please identify yourself and Ms. Squally?
Yeah, Director Forky.
Okay,
This is
Your
cause
Honor.
number 23L1210. Ms. Mon?
Your Honor, this matter is up for arraignment. This is Ms. Forgy. Today, I've gone over the charges against Ms. Forgy. She understands the charges and the penalties against her because of these charges. We will be stipulating to probable cause for the purposes of today's hearing only, and we will be entering into a not guilty plea. She also qualifies for the appointment of a public defender at no cost to her due to currently not working. So I will also ask for the appointment of my office to her matter.
Thank you. Is your true name Jerica Page 4G and is your date of birth December 17th, 1993?
Yes, sir.
Could you please provide a good mailing address for the court?
I don't have one, sir. I am homeless right now.
Okay. Thank you for that. Ms. 4G, you come before the court today for arraignment on one count of theft in the third degree. That charge is a gross misdemeanor, which means if you're found guilty, you could face a sentence of up to 364 days in jail and a fine of up to $5,000. I will accept counsel's stipulation to probable cause for purposes of setting conditions of release. I will make a finding of probable cause based on that. I will accept a plea of not guilty at this time, and I will appoint counsel to represent Ms. 4G at no expense to her. I'll next address conditions of release, and I'll start with the city.
Your Honor, the city does have concerns for reappearance in this case. However, we are aware that Ms. 4G is indigent and homeless, and so I am not going to ask for bail at this time. We would like her to take steps towards quashing 4 open warrants in other jurisdictions, those being
Can I say
Municipal
something
Court,
real?
Snohomish County Everett Division, and Tacoma Municipal Court. And we would like to request, instead of bail, that her next appearance be mandatory under Rule 3.4.
Can I say something real quick, please?
Ms. 4G,
Ms. Forgy.
Ms. 4G, I would advise that you not say anything on the record because these proceedings are recorded and
Okay.
anything you say in court can be used against you in a future court appearance. So I would advise, you do have counsel representing you. I would advise you to let your lawyer speak on your behalf.
Yes, sir. Thank you.
Thank you. Ms. Mann?
Your Honor, we have no objections to those conditions.
Ms. 4G, I will release you on your personal recognizance. So what that means is I'm going to release you on your promise to come back to court. There will be certain conditions placed on your behavior. Those conditions will be appear timely to all scheduled court appearances. And I'm going to make that an in-person mandatory appearance, okay? So you have to show up in person. Do you understand that?
Okay.
I'm sorry, did you understand that?
Yes, sir. Yes.
Okay, very good. Have no criminal law violations. Update any address changes immediately with both the court and departmental licensing. Use only your true legal name and date of birth. Do you understand those conditions?
I do, sir. I also don't have a phone right now. I'm working on getting a new one too.
I'm sorry, I couldn't hear you.
She's indicating she doesn't have a phone right now. I did let her know that my office's contact information will be on the document and she can give us a call and give us any updates and be in contact with us.
Okay, very good. Did you hear that, Ms. Forgy?
Yes, I did.
Okay, very well. So, I understand that you have some challenges right now due to not having a phone and being unhoused, but, when you're released from custody, I hope you can get access to a phone as soon as possible so you can contact your attorney and then schedule a time to meet with them.
Yes, sir.
Okay, so I'm gonna set a pretrial date. Ms. Forgy, is it possible for you to come back to court on May 9th, 2024 at 2 p.m.?
Can we do, like May 4th?
I'm sorry, what date was that?
May 4th. I have one on May 2nd, so having them close together would be easier.
Okay, well, I have a couple of choices for you. We can do May 2nd, we can do May 9th, or May 28th.
May 9th might be better.
May 9th?
Yes, sir.
Okay, so that'll be at 2 p.m.
Okay, sir. And that's in Lakewood, correct?
Yes, that's in Lakewood, yes.
Okay. Where in Lakewood where would I have to go?
The court address will be on the court order that you'll receive.
Okay.
Do you know where the Lakewood City Hall is?
No, I do not, sir.
Do you know where the Lakewood Town Center is?
Yes, sir.
Okay, so the Lakewood City Hall is located in the Lakewood Town Center.
Oh, it's by the DSHS, correct?
Correct.
Okay, yes, I do know.
Okay, very good. All right, I've prepared a conditions of release order. I'll ask the parties to review that, and if it looks accurate to the court's oral ruling, go ahead and sign that, and then I'll sign it after you guys.
I hope her luck improves. She seems to be having a tough go at things. But after her, we're going to pop on over to Travis County because
Your Honor, I've signed the document.
I forgot
Thank you.
something that I saw earlier that I was going to clip. And since it's up,
Your Honor, there's nowhere for me to sign, but I have reviewed and it looks good.
Very good, thank you. I'll go ahead and sign that document at this time.
it's the hair.
So Ms. Forgy, we'll see you back in court on May 9th at 2 p.m.
Thank you.
Best of luck to you.
Thank you.
All right.
To a bail bond, a personal bond, but you need to make sure you show up for all your court dates. Okay, you're not requesting one now, but if you decide, look will be attached to your paperwork to send that in. You won't have to pay any court when you're supposed to.
Entre los documentos que le
Is there anyone else who needs a Spanish translator before I let go of the interpreter?
¿Hay alguien más que necesite intérprete al español antes de despedir al intérprete?
No? All right. Thanks a lot, Catalina.
You're very welcome. Thank you.
All right. Just hold on just 1 minute. I'll be right back.
Officer, that gentleman back there is currently on for a murder charge.
Okay.
All
All right. I am going to need to talk to you more about it. So just sit tight. Let me get through these. All right. All right, gentlemen. Now, I know all of you want to get out of jail. If you're able to get out of jail, you need to make sure you show up for all of your court dates. If you don't, you will be rearrested and be a lot more difficult for you to get out of jail once you're back here. So if you're able to get out of jail, don't throw away your paperwork. Pay attention to when you need to be at court. Now, there are 4 ways to get out of jail, and I'll explain each one of them. First way is to qualify for a personal bond. If you qualify for a personal bond, you'll be released for free based on your promise to come to all your court dates. You'd have a bond amount set, but you wouldn't have to pay any of the bond amount in order to get out of jail. And as long as you show up for all of your court dates, you would never have to pay the bond amount. Now, personal bonds are offered in instances where the case is not too serious and where we have a reasonable certainty that you'll come to court when you're supposed to, and that you won't be a danger to others or society if we let you out of jail while your case is pending. Bail bond companies tend to charge around 10% of the bond amount as their fee to get you out. So for example, if your bond amount's $5,000, bail bondsmen often charge you around $500 or more as their fee to get you out. You can also go through a lawyer. An attorney can come down here and try to convince me or one of the other judges to give you a personal bond that you weren't able to get on your own. A lawyer can advocate on your behalf based on the unique facts of your case and your situation and try to get you a personal bond. If you don't have the money to hire your own attorney, you can request a court-appointed lawyer. And your court-appointed lawyer can do the same thing and try to get you out of jail. The last way to get out is to pay the full amount of the bond in cash.
No, the one that they need to have make the video. I don't know if y'all remember, but there's this guy, and as he's explaining the ways of getting out, he's like acting them out. He's like, you know, number 3 is if you want, you can fight the charges. He's so funny. Oh my gosh. Oh yeah. After we watch this one, because this is only like 20 minutes, 30 minutes long or something like that. Then after we watch this one, then I'll see if that other judge has one on here, because he's from the same Travis County.
If someone comes down to the jail with the full amount of the bond, not 10%, but the full amount in cash, cashier's check, or money order, then you'll be released. And as long as you come to all your court dates, at the end of your case, you'll get your money back. Whereas if you go through a bail bondsman or a lawyer, whatever money you pay them, you generally won't get back. That's their fee to get you out of jail. Those are your 4 ways to get out. Qualify for a personal bond, hire a bail bondsman, hire a lawyer, pay the full cash bond. Regardless of which way you use, make sure you come to all your court dates or you will be rearrested. I'm going to call your names. I'm going to tell you what you're charged with and your bond amount is. And at that point, I'm going to ask you whether you want a court-appointed attorney or whether you want to hire your own lawyer. If you have any questions at that point, go ahead and ask me. I'll do my best to answer your questions. If you want to know the punishment range of the charge that you're facing, just ask me and I'll tell you. All right, Ronald Tate.
Yes, Your Honor.
Mr. Tate, you are charged with a Class B misdemeanor driving while intoxicated. Your bond amount set at $2,000. However, I am going to do a personal bond in your case. You can be released today for free. Make sure you show up for all of your court dates. Do you want a court-appointed attorney or do you want to hire your own lawyer?
I'm not sure at this time, Your Honor.
Okay.
I haven't spoken with anyone yet, so I really need to speak to my wife and see if we have the funds.
All right. Well, I'll indicate right now that you're not requesting one. If you get to court and you realize you just don't have the money to afford one, then you can let the judge know then that you would like to be considered for a court-appointed attorney, okay?
Yep.
Now, for any of you, just so you know, for those of you who get a personal bond, there is a one-time $20 or $40 personal bond fee that needs to be paid within a week after your release, and an envelope will be attached to your paperwork to send that in. You won't have to pay any of the bond amount, but you do have to pay that personal bond fee within a week after your release, okay? All right. Mr. Tate, do you have any questions?
No, sir.
All right, good luck.
Thank you.
George Washington Towner. Mr. Towner, you're charged with a 3rd-degree felony driving while intoxicated. Your bond amount's $10,000. You're not going to get a personal bond because you're on felony probation for a DWI as it is out of Williamson County. And now we're back here on this one. You're going to need to go through a bail bondsman or a lawyer in order to get out. Now, bail bondsman, if they're willing to do it for 10%, if they're willing to do it for 10%, it'd be around $1,000. You'll have an opportunity to use the phone a little bit to try to get a hold of friends or family and try to bond out. Now, Mr. Towner, if you do postpone and get out of jail, regardless of how, you have a number of bond conditions you need to comply with, okay? First of all, you are required to install an ignition interlock device on your vehicle. Do you know what that is? A little breathalyzer machine? You need to install that device on your vehicle within 30 days of your release from jail. You cannot drive any vehicle at all until that device is installed. So it's not like you can drive around without it for 30 days. You cannot drive at all until it's installed. So you have an incentive to get it installed as soon as possible. And you will have 3 days from your release to contact Travis County Pretrial Services to set up an appointment with them so they can walk you through this process and answer any questions you have, okay? That number will be attached to your paperwork when you get out of jail. Second of all, Mr. Towner, you are required to have an alcohol monitor installed on your leg in jail before you're released, which means you're not allowed to drink whether you're driving or not. And if you do drink, it's going to be registered on the monitor and you're going to be rearrested. Do you understand that?
Sir.
Make sure you don't drink. If you postpone, the monitoring agency is going to come and install that device and go over payment arrangements and rules and all that and answer your questions on that. And thirdly, you are required as a condition of your release to be screened for alcohol counseling. So when you get out of jail, you'll have a piece of paper telling you where to go to do this screening. You need to go to whatever classes or group meetings that they require. Do you understand that?
Sir.
All right. All right. Do you want a court-appointed attorney or do you want to hire your own lawyer?
Don't know at the moment.
Okay. I'll indicate you're not requesting one now, but if you decide later that you need one, you can bring that up when you go to court.
Sir.
All right. Any questions?
No, sir.
All right. Good luck.
Thank you.
Steve Borath.
Right, sir.
Mr. Borath, you're charged with a Class B misdemeanor criminal trespass. Your bond amount set at $100. Mr. Borath, you refused to interview for a personal bond. Why is that? Do you not?
I would never ask that, sir. I wouldn't ask. I would love a personal bond.
Well, according to the personal bond people, they called you multiple times to
No, sir.
and that you just ignored them.
No, sir. I was probably asleep, sir. I apologize.
All right, Mr. Borath, I'm going to send them back one more time to interview you based upon this type of offense, and you haven't been in trouble oh no, you've been in trouble ever. Don't tell me that. You've been in trouble. You had a nice little run there in the teens, okay? So don't tell me you've never been in trouble. However, you've gone a little bit without getting in trouble, and this is based on the particular facts of this case. And I know you're broke. I'm going to give you a personal bond, but you need to make sure you show up for all your court dates. Do you understand that?
Absolutely.
Okay. Now, one of the conditions of your release, though, Mr. Borath, is you are not allowed to go on the property of the Austin Rec Center over there at
You should make one of the conditions of release that he get a job so he ain't so broke.
1301 Shoal Creek Boulevard. You understand you can't go back there?
Absolutely.
You can't go on that property. We clear?
Absolutely.
All right. I'm going to send them to interview you. Make sure you answer their questions. If you don't answer their questions, you're not going to get out on a personal bond.
Yes, sir.
You want a court-appointed attorney or do you want to hire your own lawyer?
I would want a court appointed.
You want a court-appointed?
Yes, please.
Do you have any questions?
After I see the PR bond people, since you're granting it, I'll be going home tonight.
You'll be released later today.
Okay, thank you.
Your first court date will be written on your paperwork. Make sure you show up.
Absolutely.
One other thing, Mr. Borath,
Yes, sir.
you got some traffic tickets from back in 2017 that you've never taken care of. Now, I'm not going to hold you in jail on those. They're only punishable by a fine.
Okay.
But when you get out of jail today, you're going to have an additional piece of paper telling you when and where to go for traffic court. That's over at Municipal Court over on the east side on Burleson Road.
Yes, sir.
You need to make sure you show up for that too. You don't need a lawyer, but you need to show up.
Yeah.
All right.
I didn't even know about that. That was in 2017, you said?
What's that?
That was in 2017?
2017, that's right.
Yeah, I applied for about that. Thank you.
All right. Any questions?
No, that's it.
All right, good luck.
Thank you.
Jesus Rojas. Sorry to keep you on. Maybe it's entertaining.
All right.
All right, Mr. Rojas, you are charged with a third-degree felony assault on a pregnant person. Your bond amount set at $5,000. You're not going to get a personal bond. The law does not allow a personal bond on a case of this nature. You're going to need to go through a bail bondsman or an attorney or come up with the cash. Now, if you go through a bail bondsman and they're willing to do it for 10%, it'd be around $500. You'll have an opportunity to use the phone a little bit to try to make that happen. Mr. Rojas, if you do get out of jail, you're going to have to be required to comply with an emergency protective order in your case. I'll explain what that means. This is for the protection of Sarah and the 4 children, and it prohibits you from doing 4 things. All right. First,
I think this is in Texas, but now you've got me seriously questioning myself. But I'm pretty sure it's Travis County in Texas, not Michigan.
First of all, you're prohibited from committing family violence, which is already illegal. Second of all, you're prohibited from communicating with them or members of the household or family in a threatening or harassing manner. So if you talk to them over the phone or something like that, you just need to be careful how you communicate with them. You understand that?
Yes, ma'am. But okay.
Let me, hold on. Thirdly, you are prohibited from going within 200 yards of 1302 North Point Drive in San Marcos, Texas, which is where your wife's moving to. You're not allowed to go within 200 yards of that address. Do you understand that?
Yeah, that ain't my wife.
Okay, well, whoever she is to you, you can't go within 200 yards of her address. Are we clear?
Yes, sir.
Well,
And then you're also not allowed to go within 200 yards of the kids' schools at Travis Elementary at 1437 Post Road in San Marcos, and at Owen Goodnight Middle School at 1301 Highway 123 in San Marcos. You can't go within 200 yards of those.
That's fine. That's no problem. I live in Austin anyways.
I understand. Just make sure you stay away from those locations.
I got you.
Lastly, you're prohibited from carrying a firearm or ammunition. Now, this protective order is going to last for 2 months until June 10th. You're going to get a copy of it. Make sure you read it and comply with it, because if you violate it, it is punishable by up to a year in jail. Do you understand that?
Yes, sir. And what happens if when my daughter's born? My daughter's born on June 9th.
I'm about to address that. So, Mr. Rojas, I know that she's pregnant, and I know that she's due in less than a month. Now, you're not prohibited by this protective order from talking to her over the phone or from seeing her at some other location like the delivery room at the hospital. But you are not allowed to go within 200 yards of her address. And you're not allowed to communicate with her in a threatening or harassing manner. So
I never did, Judge. I took care of this woman for 9 fucking months. I chased her.
I don't want you to get into all that.
All right. You're right.
What I am telling you,
yes, sir.
Talk to your lawyer about your side of the story on things. But when my concern is,
I got text messages and everything. I got it.
All right, but you make sure you don't communicate with her in a threatening way, and make sure you don't go 200 yards of
I got you.
Or the schools.
I got you. I'm not the one with the mental problems. I got you.
You want a court-appointed attorney, or do you want to hire your own lawyer?
I got my lawyer already working on that case. He's already called the jail asking for my bond and everything, but I think we're just waiting for you to place a bond man for me. So as soon as I get out of here, I'm gonna get on the phone and I'm gonna contact my mom, and then we're gonna go from there.
All right, so you're gonna hire your own lawyer?
Yes, sir.
All right, who's your lawyer?
David Chambers.
Okay. All right. Do you have any questions?
No, sir.
All right. Good luck.
Thank you.
Says I already got my lawyer working on this case. As soon as I get out of here, I'm gonna call. And I was expecting him to say my lawyer. No. My mom. Okay.
William Wagner. Mr. Wagner, you're charged with a state jail felony unauthorized use of a motor vehicle. Your bond amount's $12,000. The reason it's as high as it is because you keep getting arrested for the same stuff over and over and over again. You're gonna need to go through a bail bondsman or an attorney, or come up with the cash. If you go through a bail bondsman, and they're willing to do it for 10%, it'd be around $1,200. You'll have an opportunity to use the phone momentarily. Do you want a court-appointed attorney, or do you want to hire your own lawyer?
I would like a court-appointed attorney. But in this case, I was actually subcontracting for a recovery company.
Talk to your lawyer about that. I don't want you to make any statements about the case. I don't mean to cut you off, but just listen. This is a recorded proceeding. Whatever you say can be used against you. I cannot discuss the facts of the case with you without your lawyer present, and that's for your protection. Aside from that, I can tell you that I've read the whole police report, and I'm familiar with the things that you communicated to the officer about your side of the story on it already, and I've read that, and I'm familiar with it. But you're going to have to discuss that with your lawyer. What I can tell you is that I do agree that there is probable cause to charge you on it. Now, you have the right to fight that, and you can also request an examining trial to argue that there is no probable cause. But that's something you're going to have to discuss with your lawyer.
The reason why I brought that up was I was hoping I could get a PR bond because I do have a day job as well.
Yeah, Miss, I'm not willing to do it. I don't mind you asking, okay? But I'm not going to do a personal bond. I can't count how many times you've been arrested for this type of a charge. I mean, it's going all the way back to 2006, burglary of a vehicle. Okay, just on unauthorized use of a motor vehicle's convictions. 1, 2.
That is correct. But in this case, I've never asked for a PR bond, period. Never. And in this case, I am asking for a PR bond. So
well, I can understand why you wouldn't ask for it because you keep getting arrested over and over for the same thing. And I don't know who would give you one. I mean, you just don't, I mean, this is a constant thing. And you just got arrested. You just got arrested last month for possession of controlled substance. You got arrested.
Well, if that's the case, and if I'm not going to get a PR bond, Your Honor, and you told me that my options here, I would go ahead and appreciate it if we just go ahead and get this truncated and go ahead.
Sounds good. All right. Now, one of the conditions of your release, Mr. Wagner, is you're required to report to a supervision officer while your case is pending. Now, so when you get out of jail, however that is, you're going to have a piece of paper with the name and number of a person that you need to contact within 24 hours of your release from jail. You need to call them, set up an appointment, and report in whenever they require. Sometimes they may have you just call in. Other times they may have you report in person. You need to just follow their directions. Now, that's in addition to any reporting requirements you may have with a bail bond company. So just make sure you do that, all right? And besides that, just show up for all your court dates, okay? All right. Do you have any other questions? All right, good luck. Omar Nahar. Mr. Nahar, you're charged with a motion to revoke your probation on a felony theft charge. You have no bond. In order to get a bond set, your attorney's going to have to go talk to the felony judge presiding over your probation. It'd be up to that judge whether to set a bond and give you an opportunity to bond out. So talk to your lawyer. They'll know what to do to try to discuss that with the district judge presiding over your probation, okay?
Yes, sir.
Do you want a court-appointed attorney or do you want to hire your own lawyer?
No, I have my own lawyer, sir.
You have your own? Okay.
Yes, sir.
Do you have any questions?
No.
All right, good luck.
Thank you.
Taylor Monday. Taylor Monday.
Monday is negative.
Okay, all right. Ricky Haros. Ricky Haros, no. Darcy Frazier. Mr. Frazier, you are charged with a Class B misdemeanor terroristic threat. Your bond amount is set at $500 based on the facts of the case. I set your bond low, and also because I looked at your finances and I know you don't have a lot of money. That stated, because of the allegations, I'm not comfortable doing a personal bond. You're going to need to go through a bail bondsman or a lawyer or come up with the cash. Now, if someone comes down to the jail with $500, you'll be released and you'll get your money back at the end of the case. You can also talk to your lawyer. If you request a court-appointed lawyer, they'll reach out to you in the next couple of days. You can talk to them about what they could do to help bond you out. Do you want a court-appointed attorney or do you want to hire your own lawyer?
Court-appointed.
All right. One of the conditions of your release, Mr. Frazier, if you do postpone and get out, is you're required to be screened for alcohol counseling. You'll have a piece of paper telling you where to do that screening. You need to go to whatever classes they require, okay? All right. Do you have any questions?
How long is the jail stay for the charge?
Well, if you were convicted, the punishment ranges anywhere between a day all the way up to 6 months in jail or probation. So it's a very large range. When you go to court, your attorney is going to negotiate with the prosecutor what they're willing to offer you, and then you can make some decisions at that point. Of course, you have the right to fight your case or try to get it pled down to a lower charge. Those are things you need to discuss with your lawyer. All right. All right, good luck. Giovanni Maldonado.
Oh, this is fun.
Mr. Maldonado, you're charged with a Class A misdemeanor assault causing bodily injury to a family or household member. Your bond amount set at $5,000. You're not going to get a personal bond because you're already out on bond on a felony assault domestic violence case as it is. And so the law does not allow a personal bond in this case. You're going to need to go through a bail bondsman or a lawyer to get out. Bail bondsman, if they want to do it for 10%, be around $500. You'll have an opportunity to use the phone momentarily, okay? So you want a court-appointed attorney, or do you want to hire your own lawyer?
At the moment, let's go with the court appointed, but I think I'm gonna go for a hired attorney later on. But I'm just for the moment, you know.
Understood. If you end up hiring an attorney later, they can substitute in for the court-appointed lawyer, okay?
Yes.
All right, any questions?
No, at all.
All right, good luck.
Oh,
Thank you.
it might be the next guy.
Jeremy Mercer.
I think it's that bald one actually that's really fun.
Mr. Mercer, you are charged with a Class B misdemeanor criminal trespass with a bond amount of $100 and a Class A misdemeanor resisting arrest or search with a bond amount of $500. Total amount of your bond $600. Mr. Mercer, who do you live with? What's that?
I'm
You live with your mom over on Rosewood? No, Leona?
that's my baby's mother's house,
That's your what?
baby's mom's house over there.
Okay, but you live with your mom. How long you been staying with your mom?
She's been there a long time.
Are you working?
Yes, sir.
Where do you work?
Somewhat as a day labor.
Day labor?
Yes. I can make those court days, Judge, I guarantee you.
I'm gonna give you a personal bond, Mr. Mercer. You need to make sure you show up for all of your court dates.
I appreciate that, Judge. I'll be there, I promise.
You also are required to stay away from the Scottish Inn at 6201 East US Highway 290. You can't go back on that property under any circumstances. Do you understand that?
I don't want to go back, Judge. Yes, sir. I understand.
All right. Make sure you show up for all your court dates. Make sure you stay out of trouble. Do you want a court-appointed attorney, or do you want to hire your own lawyer?
We can still be able to have one.
What's that?
I think that's good. I think I'll be able to get one. Myself.
You want a court-appointed?
I think I'll be able to do it myself.
You're gonna hire your own lawyer?
Yes, sir. Yes, sir.
Okay.
Yes, sir.
All right. Make sure you show up for all your court dates. Good luck.
So I better get that PR.
I'm giving you a personal bond. You're getting out of jail today. Now I'm stretching for you on this
No,
personal.
I got it, Judge. I promise.
Yeah, you
Thank
don't-
you. I really thank you for that, man. Thank you. Thank you.
All right.
I got
Under
you.
the circumstances of this case, I'm
Yes, sir.
comfortable doing it, but you need to stay out of trouble.
Yes, sir. Thank you.
All right.
Appreciate it. Thank you, sir.
Josh Michael Perez. Mr. Perez, you're charged with a Class B misdemeanor criminal trespass. Your bond amount's $200.
Oh, it's this one.
You're not going to get a personal bond because you're already out on bond on 2 other cases. I set your bond low because the facts of the case is not too serious, and because I know you don't have a lot of money, but based upon you being out on bond on 2 other cases, you're going to need to go through a bail bondsman or a lawyer or come up with the cash. Now, I set your bond low enough to where if someone just comes down to the jail with $200 cash, you'll be released and you'll get your money back at the end of the case. You need to make sure that you show up for all your court dates. You understand that?
Yeah, for sure.
All right. So if someone comes down with $200 cash, you'll be released. If you don't show up for court, you're going to lose that money and get rearrested. You clear?
Yeah.
One of the conditions of your release, Mr. Perez, is you need to stay away from all Austin Community College property. Do you understand that?
Yeah.
You want a court-appointed attorney, or do you want to hire your own lawyer?
So let me get a court appointed.
Do you have any questions?
Oh, yeah, I got a question.
Go ahead.
How old you gotta be to bond somebody out?
What?
How old do you gotta be to bond somebody out?
Well, that's up to the bail bond company, but bail bond company, here's the thing. In your case, a bail bond company is likely not going to do it. A bail bond company isn't going to charge $20 and bond someone out. They won't even come down to the jail for less than a certain floor amount. In fact, some of them may not come down to the jail for less than $200. So I set your bond low enough that if you just can pay it in cash, then you can get your money back at the end of the case and you don't lose the money. All right. But I wouldn't, I mean, you could try and call a bail bondsman and see if they're willing to do it and bond you out, but they're not going to charge you $20. They might charge you $100. You see what I'm saying?
Quit avoiding,
But in
Judge.
terms of how old someone has to be, it's up to a bail bond company if they want to get a cosigner and what kind of cosigner that they need. They're not going to take a cosigner who's 17 years old, but unless they own property or something. You understand what I'm saying?
Judge, I really don't think he's talking about someone who's 17 years old. What a better way to say my girlfriend's underage.
Yeah, facts.
All right. Make sure you show up for court. Stay off of ACC property.
All right, sure.
All right, good luck. All right, is anybody whose name I did not call? Did I call everybody? All right. Make sure you show up for all your court dates. Obey your bond conditions. Stay out of trouble. Good luck.
Hey, Judge, appreciate it.
We're in district court.
Sorry, I lost my buttons and I couldn't figure out fast enough how to stop it. And a mute was not my biggest concern. I said I would find the judge. Oh, that's not it. If he is even I'm looking. 8.5-hour docket. Are you kidding me? There's gotta be a mistake. I'm thinking someone left the camera running, and I'm thinking I'm right. Like they thought they turned it off. Wow. Oh my. Yeah, that's what happened. And that's all she wrote. All right. That looks like an interpreter.
I don't think it's working.
Son sancionables
You'll forfeit your bail.
o cosa que
By the police of the states.
Well, I guess that was interpreter only, which was not the judge that we were looking for. Oh man, he must not have any.
Point, however, there are other ways.
confianza y no con tiempo en cárcel.
Do you have
My goodness. Now that makes me very sad because there's just Judge Mom. Oh, poo. You get some rest, sweet crazy old lady. You took a beating today. I hope you feel better, sweetie. I love you. I am 99% sure that docket would be pulled. I can check. The problem was that, yeah, that docket's pulled. Problem
This
was
is in the District Court of Butler County, Kansas.
my what I was exporting didn't export. I can export the most recent Kansas docket, but it wouldn't be edited at all, which is frustrating to me.
Case entitled State of Kansas versus Glenn Edwin Shack. It's case number 2023 CR 435. Mr. Shack appears in the office of his defense attorney, Chris Pate. Cheryl Pierce appears as prosecuting attorney on behalf of the state.
Well, I'm sad about
This matter comes before the court at this time for further proceedings. Mr. Pate, what announcement is made at this time?
Your Honor, we've reached a plea agreement in this case that's been reduced to writing, and I sent a copy of both Pearson the court that has my client and my signature on it. The plea agreement, Mr. Shack will plead no contest to counts 4, 5, and 6, which are charges of sexual exploitation of a child, level 5 person. All remaining charges will be dismissed. This is going to put Mr. Shack in a border box finding, or a border box category. The defense will request border box findings. The state will stand silent on the border box findings. Didn't specifically spell it out in the plea agreement, so I should probably confirm record with Ms. Pierce. In the event Mr. Shack has unanticipated history that places him in a presumptive prison box, the defense would be requesting the ability to file a departure motion. The state could take whatever position it felt. We anticipate this charge will require registration under the Offender Registration Act for life. We do need to get a notice of duty signed. I believe Ms. Pierce was going to try and get that form emailed over to our office so we could complete that after the court takes the plea today.
Right. Ms. Pierce, you've been present and heard the statement of Mr. Pate as to his understanding regarding the plea agreement. Are you in agreement with the announcements that Mr. Pate has made?
Judge, are you talking to me? I'm sorry, I
am talking to you, yes.
Okay, I'm sorry, I didn't catch the beginning. Yes, Your Honor, I am. And we do have a written agreement. I can email that over to Mandy or yourself if you want me to. That
I have it before me, counsel. I have it.
Oh, you do? Okay, great. And I did just get off the phone, or my assistant just did get off of the phone with court services, and they are preparing that notice of intent to register. So we should have it by the time we get ready to end the hearing today to get to Mr. Pate.
Oh, very well. Mr. Shack.
Yes, Your Honor.
You've been present when your attorney made an announcement on your behalf, and you've also signed a document, apparently defendant's acknowledgement of rights and entry of plea. Do you know the document that I'm talking about here?
Yes, Your Honor.
Mr. Shack, did you read this thing thoroughly before you signed it?
I did.
On page 5, there appears to be on Glenn Edward Shack, defendant line, your signature. Is this indeed your signature?
Yes, Your Honor.
All right. It contemplates that you'll be entering a plea of no contest to certain charges in this case. There are a number of questions I need to ask you regarding the taking of a no contest plea. If there is any question asked of you that you do not fully understand, I will give you the opportunity to confer privately with your attorney before we go any further. Just let the court know if you need that time to confer and get additional advice. Okay, Mr. Shack?
Yes, Your Honor.
All right. Let's start off by having you state your full legal name for the record.
Glenn Edwin Shack, S-H-A-C-K.
How old are you right now?
46 years old.
What's the highest level of education that you've attained?
12th grade.
Now, do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here this afternoon?
I don't believe so, no, Your Honor.
All right. I see a notation on your written agreement, Mr. Shack, I want to ask you about. It's been handwritten on here, Zyprexa, an antipsychotic. So have you ever been adjudged to have any type of mental illness or condition?
No, Your Honor.
Okay. Is this prescription medication, the Zyprexa?
I've taken it since I was 18.
Okay, at some point you saw a mental health professional and this was prescribed for you?
Yes, correct.
Okay, what is the condition that you were diagnosed with?
I was having trouble sleeping, loss of appetite, stress, things like that. I was
Have
18.
you ever had a formal adjudication that you're mentally ill?
No.
All right, now this antipsychotic medication, and apparently you've been taking for a long time, does that improve your mental condition?
Yes, Your Honor, it does.
Does it in any way impair your ability to understand what's going on, such as what's going on here in court today?
No, Your Honor, it doesn't.
Are you currently under the influence of alcohol or any type of drug?
No, I'm not.
I'm not really buying that guy's version of why he's on that medication. They don't go to antipsychotics as the first step when you can't sleep at night. There is something very wrong about his testimony.
So as you sit today, Mr. Shack, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
Yes, Your Honor.
Now, did you receive a copy of the second amended information in this case, Mr. Shack?
Yes, Your Honor, I did.
Do you have a copy of that charging document before you at this time or available to you?
Yes, Your Honor.
Okay. Mr. Pate, I am going to ask you to make sure that that is in front of Mr. Shack during these proceedings.
Yes, Your Honor, it is.
Thank you. Now, Mr. Shack, when you enter a no contest plea, you are not necessarily admitting the crimes charged in counts 4, 5, and 6, but when you enter a no contest plea, you could be convicted just the same based on that no contest plea. Do you understand that?
Yes, Your Honor.
All right. And do you understand that when you enter a no contest pleas, you're giving up any legal defenses that you might have had to those charges?
Yeah.
I'm sorry, I didn't hear it.
Yes, Your Honor.
Okay. Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your attorney, Mr. Pate, and that you can present your own evidence at that trial and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means you could testify in the case under oath at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that, Mr. Shack?
Yes.
You understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, Your Honor.
You also understand that you would have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, Your Honor.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, Your Honor.
Now, are you aware of the possible sentence that could be imposed as a result of this no contest plea that you're attempting to make to these three charges?
Yes, Your Honor.
Mr. Schack, do you have a copy of the non-drug offense grid under the Kansas Sentencing Guidelines Act before you in Mr. Pate's office?
Your Honor, may I have just a moment to go get that off my desk?
Please do, Mr. Pate.
This guy definitely does not look like he wants to take this deal, but I bet you anything it'd be worse if he went to trial.
I have it right here, Your Honor.
All right. If you'll look at this with me, if you look at the non-drug offense grid at level 5, these charges that I've been told that you're going to plead no contest to are all level 5 felonies. So if you look over in the most right column on that particular page under criminal history category I, you will see that you could receive as little as a 31-month sentence. Do you see that?
I do, Your Honor.
Over at the other end, however, in the A box, you could receive up to a 136-month sentence. Do you see that, Mr. Schack?
Yes, Your Honor, I do.
So the sentencing range for a level 5 felony crime in Kansas is 31 to 136 months in prison, depending on your criminal history. Mr. Schack, as you sit today, we do not know with absolute certainty what your criminal history is. You, better than any other participant, really should know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of that research, as of the date of your sentencing, that will determine where you fall along the level 5 line, and then you'll be sentenced accordingly. You understand that?
Yes, Your Honor.
If you look at the level 5 line again, you will see that categories H and I are shaded differently than all of the others. Do you see that?
Yes, Your Honor, I do.
That means that these are border boxes. H and I are border boxes. Now, those are presumptive prison categories. However, the court, without a departure, can discretionarily grant some sort of community-based alternative to prison, usually based on some sort of treatment being available in the community. Do you understand that that border box call, should you fall in the H and I box, would be discretionary with the court, Mr. Schack?
Yes.
Okay. You also understand that if your criminal history puts you in any of the categories A through G, this is just a presumptive prison case. Do you understand that?
I do, Your Honor.
You also understand for level 5 felonies in this state, you could receive up to a $300,000 fine for each offense.
That I do, Your Honor.
Okay. In addition to any fine that could be imposed, are you aware that you could be assessed and be required to pay court costs, certain fees, legal expenses, reimbursement, and restitution to victims, if any are owed, as part of your sentencing orders?
I do, Your Honor.
Are you also aware that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which would be the state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing?
Yes, Your Honor, I do.
You also understand for the offenses that you would be entering no contest pleas here, this could be a lifetime post-release supervision period that you might be facing.
Correct, Your Honor.
Okay. You also understand that you might have offender registration requirements for up to the remainder of your life as a result of conviction of these offenses that you're attempting to plead no contest to.
Yes, Your Honor.
No, that's the sex offender.
Okay.
All right.
My apologies, Your Honor. We're good.
That's quite all right. All right. I want to make sure you understand what we're doing here, Mr. Shack. You also understand that, Mr. Shack, the Kansas Sentencing Guidelines Act is much more than that grid page that we referred to earlier. It's an entire book of sentencing rules and laws. If any special rules apply to you in your situation, do you understand that it could affect your eligibility for probation or otherwise affect your sentence?
Yes, I do, Your Honor.
All right, Mr. Shack, do you understand the differences between consecutive and concurrent sentences?
Ones are back to back and the other ones go on at the same time together.
Okay, I think that's a good summary, Mr. Shack. You seem to have an understanding of it. That's correct. There are your cases involving, apparently pursuant to plea agreement, pleas to 3 different charges. It could make a big difference, obviously, whether these are boxcard, ran back to back, which would obviously result in a longer sentence, compared to one where they all run concurrently, where they run all at the same time, which obviously would result in a lesser sentence. So do you feel like you have a firm understanding of the differences between consecutive and concurrent sentences, Mr. Shack?
Yes, Your Honor, we do.
You also understand that whether your counts run consecutively or concurrently is a discretionary matter for the court. You understand that?
Yes, Your Honor.
Now, did you have an ample opportunity to discuss legal matters like we've discussed with your attorney, Mr. Pate, before proceeding here today?
Yes.
You want any more time with him privately now before we go any further, Mr. Shack?
No, Your Honor.
Are you satisfied with the services and advice given to you by your attorney, Chris Pate?
Very much so, Your Honor.
Now, this set of no contest pleas that you're attempting to make, has this been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No type of.
Judge, could you, the glitched out, could you just repeat that last part, please?
All right. These no contest pleas, Mr. Shack, that you're attempting to make, has these pleas that you're attempting to make been based upon any threat or a promise as to what this court would do in regards to your sentence or any other type of threat or promise?
No, Your Honor.
Okay, is there anything that you thought was supposed to be part of the plea agreement that hasn't been either accurately discussed on the record today or included in your written agreement? Is there anything else that the court needs to be made aware of as to what your understanding of the plea agreement is?
No, Your Honor.
Okay. Now, Mr. Shack, do you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court would not be bound by any agreements made? The court may and shall consider them as recommendations, but would not be bound by them. Do you understand that, Mr. Shack?
Correct, Your Honor.
Mr. Shack, how do you plead at this time to count 4, sexual exploitation of a child, a level 5 person felony?
No contest, Your Honor.
And to count 5, sexual exploitation of a child, a level 5 person felony?
No contest, Your Honor.
And to count 6, sexual exploitation of a child, a level 5 person felony?
No contest, Your Honor.
All right. Ms. Peters, I have no great delight in discussing the specifics of these individual offenses here on the record. I trust, Ms. Pierce, that at trial, your evidence would reflect what you've stated in counts 4, 5, and 6 of the Second Amendment information.
Yes, sir.
Mr. Payne, do either you or your client challenge the sufficiency of the factual basis of these offenses based on the language of counts 4, 5, and 6 of the Second Amended information?
Your Honor, based on plea negotiations and Mr. Shack's intent to enter a no contest plea and accept conviction, he will not challenge any of the allegations set forth in counts 4, 5, and 6.
I need to ask you that question personally, Mr. Shack. Do you challenge that the statements of fact which are set forth in counts 4, 5, and 6, are you challenging the sufficiency of those facts should this matter go to trial?
No, Your Honor, I do not.
Okay. All right, so at this point, Mr. Shack, do you freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for counts 4, 5, and 6, all counts of sexual exploitation of a child, level 5 person felonies?
Yes, Your Honor, I do.
Mr. Payne, do you know of any legal reason why the court should not accept your client's pleas?
I do not, Your Honor.
Ms. Pierce, are you aware of any such legal reason?
No, Your Honor.
Mr. Shack, are you aware of a legal reason or any other good reason why the court should not accept your pleas of no contest here this afternoon?
No, Your Honor.
The court will accept the no contest pleas made by defendant Glenn Edward Shack and finds that those pleas are made voluntarily. Mr. Shack has an understanding of the nature of his charges and the consequences of his pleas, and the factual basis for each count 4, 5, and 6 does exist. The court finds the defendant guilty and the judge is him therefore convicted of the crimes charged in counts 4, 5, and 6 of the information, all sexual exploitation of a child, level 5 person felonies. All other charges in the charging document are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Mr. Shack's criminal history, and the court will set an appropriate date for sentencing.
As soon as prison hits him.
Chris, I just emailed the duty to register over to you.
Okay. Your Honor, would you like me to get that document and take care of that before we do scheduling?
Yes.
That lawyer is woefully unprepared for this. He has nothing at his desk or available to him from his desk.
It is with me.
His address is different than what is on this form. I can just handwrite that in if that's okay.
It is with me.
What's your correct?
532.
La 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 la.
If you and your client would initial that change, Mr. Payton?
That has been changed, Your Honor.
All right, again, if you and your client would initial that change?
Okay.
All right, Mr. Shack, and now that you have been convicted
Might have been
as
white.
a sex offender, you've got a offender registration requirement under Kansas law. This form that's being put before you just simply notifies you of that duty, as well as these oral statements from the bench today. The normal protocol would be that you read it carefully and then go ahead and add your signature, acknowledging that you're aware of the offender registration requirement.
Yes, Your Honor.
And he has now sign that, Your Honor.
Very well. Thank you for your assistance with that, Mr. Pate. We'll go ahead and address scheduling of the sentencing proceeding in the case. Please, Mr. Pate, take into account that the sentencing in this case will be done in person at the Butler County Judicial Center in El Dorado, Kansas. The date that I'm looking at, Mr. Pate, is Tuesday, June 4. Tuesday, June 4.
I am available at any time that day, Your Honor.
I'm going to offer you either 9 o'clock or 11 o'clock a.m. What works best for you, Mr. Pate?
11 o'clock, please.
Very well. Court will set sentencing in the Glenn Shack case for Tuesday, June the 4th, 2024 at 11 o'clock a.m. Again, this will be in courtroom B at the Butler County Judicial Center in El Dorado, Kansas. Court does not approve the defendant's participation in any other manner. He'll need to be there in person on that date. Mr. Shack has not been a problem on bond for this court. He's appeared at every single court appearance scheduled for him in a timely fashion. That speaks well for you, Mr. Shack. I'm going to maintain you under your current bond pending further proceedings in the case. At the conclusion of today's proceedings, I'm going to ask Mr. Pate, while you're still in his office, to make a call to Butler County Court Services. Chris, I can give you the number if you need it.
If you could, please, Your Honor.
That would be 322-4153. Mr. Shack, please follow the Court Services Department's direction about what you need to do next to facilitate the pre-sentence investigation process. You may be asked to do a risk needs assessment. You'll need to make sure that that gets scheduled and completed in enough time that we don't have to delay the sentencing. If you don't take care of that, Mr. Shack, I'll hold you accountable at sentencing if we're not ready to go, which probably means you're going to be going to jail. So we're going to allow plenty of time between now and sentencing to get this done. So get it scheduled, completed as soon as you can in the process. Any questions about that, Mr. Shack?
No, Your Honor.
Okay. Again, stay in the office until Chris makes contact with Court Services. He'll give him the information regarding the plea, and then you'll get some further direction from that office as to what you need to do next. All right. Ms. Pierce, is there anything else from your office's perspective that needs to be addressed regarding Mr. Shack at this time?
I just need to know, is Chris going to email that notice of intent to me or to the court? Because the court will have to sign it. Or how's he going to do that?
Chris, send that to my assistant, please.
Okay, I will.
Thank you, Judge. I have nothing further.
And then we'll make sure it gets filed one way or the other, Ms. Pierce.
Thank you.
All right. All right, Mr. Shack, I want to make sure I ask you personally. We've covered a lot of ground here today. You have any questions or concerns about what we've done here today?
No, Your Honor, I do not.
Mr. Pate is an experienced and a good lawyer. If you have anything that comes up, seek his advice and follow his direction.
Yes, Your Honor.
Okay. Go ahead and make that call to the Court Services Department at this time. If there's nothing further, the Shack matter, Mr. Pate?
Sorry, Your Honor. I did want to address one of his bond conditions, if I may.
Go ahead.
And Mr. Shack, he's very appreciative of the fact that the court reduced his bond on September 20th down to $50,000. At the time, he was facing multiple off-grid felony charges. One of the court's conditions was that he be on an ankle monitor during the pendency of the case. Now that he has entered a plea to less severe charges, I understand there's still border box and the court has some decisions it's going to have to make, but we're dealing with a much less serious situation. Mr. Shack has always appeared for court. He's been in excellent contact with me the whole time. It's becoming quite costly for him to maintain that ankle bracelet. We would ask the court consider allowing him to remove that pending sentence.
No.
State's position on this request, Ms. Pierce?
Judge, I don't really have an objection. He has appeared, he's at all hearings. The only thing I would ask is that the court continue the order not to leave the state, not to leave the county or Sedgwick County, which is, I think, typical. Other than that, I think I don't have an objection to the removal of the EMD.
It's a reasonable approach. And the court will at this time remove the ankle monitor requirement, Mr. Shack. You've proven yourself by consistent, timely appearance in court. And I think you probably know the implications of you not showing up next time.
Sure.
I'm going to remove the ankle monitor requirement at this time. That can be taken off. But again, with the restriction that you're to not obviously leave the state, because you can't leave the territory, which consists of Butler and Sedgwick County only. You need to confine your presence to that geographical location only, Mr. Shack. That remains a bond condition. Obviously, you need to comply with the pre-sentence investigation process as a condition of bond, as the court earlier noted. But that can go ahead and be taken off at this time.
Thank you.
Well, you've earned that, Mr. Shack. All right, Mr. Payne, anything further from your side?
Not at this time, Your Honor. Thank you.
All right, very well then. There's nothing further. The State versus Shack matter will currently be in recess, and this meeting may be ended for all.
Hello.
No, I am not streaming Mike's stream. Yeah, I gotta go too, guys. I'm getting sleepy. Well, I mean, he posted bond. They can't really hold him in there. He was eligible for a bond. So that happened before this hearing even. But what the modification was that they made this time is they're not going to make him continue with the ankle monitor because of the cost involved. So June 4th is his sentencing date. It's probably going to be in front of Judge Hart, would be my guess. But I have something medical that day. I don't remember what or why. I just remember them scheduling something on June 4th. So I will have to figure out what that is. Yes. Have a wonderful, happy day, Salty. Thanks for coming here, buds. We miss you all the time when you're not here. Good night, Shane. Thank you for being here all the time for me. I appreciate you. Good night, Foxtrot, and you drive safe. Good night, my sweet sis Tammy. Good night to all the replay crew and everyone else. I again apologize about the exporting issue, but at least I'm, somewhat ahead on my content for tomorrow. Hey, I'll be able to throw an extra clip or two into it. Because it's first appearance docket, and there was a point where something from what would have streamed today, they're like something about reset till tomorrow, blah blah blah. Well, the docket was from today. Well, yeah, from Tuesday and Wednesday. And then on Wednesdays, they mentioned, well, we'll reset this hearing for Thursday. Can't remember the reason. But I'll be able to add on just the one hearing. I don't want to do another, 45 minutes or an hour or whatever added on to it. But just that one hearing I can add on to that spot. So, All right, you guys. Sorry about the mix up, but I do love you all so much. Be safe, be well, sleep sweet, and much love.